Today we're talking about character evidence and the forms of the evidence that you can use. Now, if we think about character evidence as these four categories, I want you to start by excluding one of them. That's character evidence, anything that's labeling someone or telling a story about someone so we can hope that the jury infers such a label. If it's about a witness, like this top left-hand corner, if it's about a witness, separate it out. It belongs somewhere else. It belongs in Article 6, which governs witnesses and impeachment and this character for truthfulness, or as we put it here, propensity to lie. True character evidence, definitional character evidence, belongs in these other categories. We focus on definitional character evidence, including the word propensity. That is, we're introducing bad stuff about a party or a criminal defendant or a victim in a criminal case. We're introducing something about them, whether it's a label about them or whether it's a story to demonstrate some label to show that they acted in propensity, with a propensity for that characteristic, to show that they acted in conformity with that characteristic in this case. Bottom left, you see sometimes very limited instances, only a few times do we have character as an element of the crime or defense or proof that we must put on. And then for a different video, we have when it's something else, when it's offered for something else, when it looks like character evidence, smells like character evidence, but it's offered for something other than propensity. This is your classic 404B type evidence. So let's talk about the forms of evidence. Here we go. We have opinion, reputation, and what I call story time, specific instances. The first two are really easy to recognize. I, witness, I, character witness. I hold the opinion that this person, either the criminal defendant or the victim, or sometimes parties in a civil case, this person, I have the opinion that this person has this character trait. Reputation, I know this person in the community, in some limited community, I know their reputation for a character trait. Those two are sort of easy to recognize. They kind of jump off the page with either voicing an opinion or talking about someone's reputation for a certain characteristic. The hardest one, and for me the most persuasive form of evidence, is the story time stuff, the specific instances. I'm not going to tell you that the defendant's dangerous. I'm not going to tell you that the victim is dishonest. Instead, I'm going to tell you a story that more vividly demonstrates that. So now we're going to look at those three types of evidence that we're talking about. The propensity evidence, classic 404A, that you shall not introduce. Character evidence for propensity is out. We don't like it and the rules exclude it. That second one to prove essential element under 405B. And then again, if we're offering something that looks like character evidence, sounds like character evidence, but it's offered for some other purpose than propensity at trial, the 404B evidence. If we look at these three categories, the big broad categories of character evidence, really what we need to think about is most oftentimes general rule not allowed, but when it is for propensity, when we allow it, and particularly when we allow the criminal defendant to use it, they can only use the two very unpopular, very unpersuasive forms of evidence, opinion and reputation. When it's an essential element, they can use any of the above. When it's not offered for propensity, so technically not really character evidence, they can use all of the above. They can tell stories. But when we allow it under the rules, when we allow it for propensity, when we allow character evidence to prove that ultimate thing that we don't like character evidence for, propensity, it's only reputation and opinion per 405A. It's not going to be. So now we have to think about that general rule. Never lose sight of the general rule. If it is truly character evidence, that is character offered for propensity, offered to prove that someone acted in conformity therewith, 404A starts by kicking it out. If it has to do with a criminal defendant, a victim in a criminal case, or sometimes parties in a civil case, if it have to do with these central characters in our case, not witnesses, then you got to start with this general rule that it is generally out. That's right, character evidence for propensity is generally out. And very, very narrow exceptions are allowed. Very, very narrow exceptions. So don't think about it like hearsay. Think about character evidence when offered for propensity is out. We have these mercy rules, which essentially we allow the defendant to turn the key. It is the defendant's choice. So it applies only in criminal cases. So if you have character evidence talking about parties in a civil case, talking about characters central to that civil case, not witnesses, and we're just trying to show that they acted in conformity with some characteristic, it's out in a civil case. It applies only to criminal cases. Next, it is up to the defendant to turn the key. The prosecution cannot start by using any of these exceptions. The prosecution simply cannot make it part of their presentation, their government's case in chief, to introduce character evidence about for propensity. The definition of character evidence includes propensity, includes conformity therewith. Cannot happen in the government's case. If it's offered for propensity, it is out. Go back to that general rule. These mercy rules allow the defendant in his case in chief to introduce evidence. Very narrow, because it's evidence about him, his character, often good character, or the victim. In cases that have victims, the victim's character, often bad characteristics. So think about it. In an assault case or in a violence-oriented case, a violent offense, if he's going to introduce something about his character, it's most likely going to be his character for peacefulness. If he's going to introduce something about the victim, it's most likely going to be the victim's character trait for violence or to being violent. So think about that. We allow the defendant to make the choice. The mercy rules allow the defendant to make the choice. So not only does it have to be a criminal case, but it also has to be the defendant initiates. Next, it must be pertinent. The rules and the exceptions in 404A say it's only pertinent stuff. So we talked about violence and peacefulness in an assault case. Same thing with honesty in a theft or embezzlement case. It has to be related, has to be pertinent to the charge, making these mercy rules even more narrow, the exceptions even more narrow. And again, we're talking about form of the evidence, reputation and opinion only. So even if it's a criminal case, even if we allow the defendant to make the choice, he wants to say some good news about himself through a character witness, or some bad news about a victim and their character through a character witness, we only allow them to do so by reputation and opinion evidence. And we're going to talk about what that means. And then the prosecution can only respond. And the way they respond, they can respond through cross-examination. They get to ask cross-examination questions of the defendant's character witness. But if they're going to call their own witness, if they're going to talk about maybe some bad news for the defendant or some good news for the victim by way of character witness, they have to call it in their rebuttal case. So think about the landscape. Now, to put on reputation and opinion evidence. Do you know this defendant? Yes. How do you know them? Oh, I've known them for years, and here's our level of interaction. Do you have an opinion, or do you know the reputation of this person for that pertinent characteristic? Yes, I do. What is that opinion? He has this reputation. He is peaceful, or she is violent, or he does have this reputation for peacefulness or violence. That is it. So recognize how terribly unpersuasive reputation and opinion evidence can be. It's the only form that's allowed, but it's just not that good a form of evidence, and that's the only one we allow. So even when it's a criminal case and when the defendant has opted to make character evidence through a character witness part of the case, they have to use this reputation and opinion. The same thing if the government's going to respond. And here's 405. Essentially, 405A prescribes this, and it says you got to keep it to reputation and opinion. No story time, no specific instances. Now, in cross-examination under that same rule, we can ask specific instances, but I want you to think about it like this. They're all did you know questions. If a character witness has come forward and a character witness comes up and says, one of the characters in the criminal case, the criminal defendant I have an opinion that they are peaceful. I have the opinion that they are violent. The victim, I have an opinion that they are peaceful or they are violent. The cross-examination questions, oftentimes from the prosecutor, because they're going to be defense character witnesses, cross-examination questions from that prosecutor is Mr. or Mrs. character witness. Did you know about this specific thing? Did you know about this story? Now, of course, the questioner has to have a good faith basis for asking the question, but they are only probing the opinion. And notice they are stuck with the answer. It's yes or no. So essentially, you say that the defendant is peaceful. Did you know that he used to beat up his brother repeatedly throughout high school? If the answer is no, that speaks to the opinion and the value of the opinion. If the answer is yes, that also speaks to the quality of the opinion, but you are stuck with the answer. There is no proving it up. Look at the landscape of how 404A and those narrow exceptions work together with 405A and the form of the evidence. It sort of looks like this. It's generally going to be out. 404A says character evidence, that evidence offered for propensity to show that someone acted in conformity with some characteristic is out. There's a couple of ways that the accused can turn the key and introduce good stuff about himself or bad stuff about a victim, and then the prosecution can rebut the same. But when they do so, when they introduce character evidence for propensity, definitional character evidence, when they use these limited exceptions, it's reputation and opinion only. It's that terribly unpersuasive form. They can't tell story time. They can't say, I have a great story from high school to demonstrate that the defendant is peaceful. They can't say I have a great story from her past to say that a victim is violent in the past in this assault case involving the victim. It has to be reputation opinion. It has to be that, do you know this person? How long have you known them? The level of interaction. Do they have an opinion as to this pertinent characteristic? I do. What is that opinion? That's it. And then remember on cross-examination that we're going to allow the did you know question. The cross-examiner can say, did you know about this specific act? Did you know about that specific act? And think of the landscape in the case. Never in civil cases. Just doesn't happen because we're not going to introduce propensity evidence in a civil case. Prosecution's case in chief, they similarly are not allowed to introduce character evidence, the definition for propensity to show that someone acted in conformity therewith. It's going to come up in the accused case, their option, so they can introduce some stuff about themselves, stuff about the victim, and then in the prosecution's rebuttal case, we'll get into some of the rebutting in kind. Even when they do that, even when the prosecution rebuts, it has to be reputation and opinion only. So don't lose sight of the form of the evidence. There are three forms: reputation, opinion, and specific acts, which I call story time. As it relates to propensity, character evidence offered for propensity, the definition of character evidence, it's generally out, but we're only going to allow reputation and opinion when we allow the defendant to control it or the prosecution to rebut. The other forms of evidence we'll see, whether it's 404B evidence, stuff that looks like character evidence but not offered for propensity, or character evidence that's an element of the crime or defense or claim, we're going to let them get into specific instances then, but not when offered for propensity like here.